At the Chesterfield County Juvenile and Domestic Relations District Court, judges are responsible for determining custody, visitation, or support of a child who lives in the county when a parent, guardian, or a person with a legitimate interest petitions the court. We're also responsible for addressing any requests to change those orders. This process can seem confusing at first, so we've assembled an overview of what you can expect from beginning to end. If this is the first time you are asking a court to make a decision about custody, visitation, or support of a child, you will first visit or contact the Court Services Unit. If you are interested in requesting a change to a current court order, you will visit the clerk's office. Both offices are in the Juvenile and Domestic Relations District Courthouse located at 7000 Lucy Core Boulevard, Chesterfield, Virginia 23832. Contact the Court Services Unit by phone at 804-748-1372 or visit in person at the courthouse. An informational packet will be provided. Complete the attached worksheet and return. An assigned intake officer will contact you to explain the next steps. The Court Services Unit is open Monday through Friday from 8 o'clock a.m. until 4:30 p.m. The clerk's office is open Monday through Friday from 8 a.m. to 4 p.m. Remember, completing the necessary paperwork and receiving answers to your questions may take time, so please allow at least an hour for your visit. When visiting the Chesterfield Juvenile and Domestic Relations District Court, be sure to bring physical or printed copies of a government-issued photo ID, the legal names of the child and each parent and legal guardian, the child's social security number if known, the current address of each parent and legal guardian. If you don't know where someone resides, then provide a current work address. The court must send notice and a copy of your request with the date and time of the court hearing to each parent and legal guardian. If you are unable to determine where someone lives, speak with a representative in our offices for more information. And if your case was subject to a prior court order, bring a copy of those prior orders as well. Upon entering the courthouse, you will go through a metal detector and a simple screening process. Please be aware that once inside, you may be subjected to a search. COVID-19 restrictions preclude entry of anyone who does not have business to conduct in the courthouse. Personal electronic devices such as cell phones are permitted in the courthouse. However, use of the device may only be directed by the judge. Recording or live streaming is strictly prohibited. Coming to court can be very stressful, even traumatic, especially for children. Many of the courthouse personnel have received training at being trauma-informed. Our facility dog, Mitzvah, or Mitz for short, has been taught specialized skills to comfort someone under stress. His name means good deed. Children and adults at the courthouse have appreciated Mitz's many good deeds. Courthouse staff and service providers have a wellness room available for their use. Staff and service providers caring for themselves allow them to better care for others. After passing through security, you will visit the Court Services Unit if you are looking to file a new petition, or the clerk's office if you want to request a change to a current order. Have a question about where to go? Ask one of our deputies. Deputies, clerks, and intake officers cannot provide legal advice, but they'll do whatever they can to assist you. We understand that completing paperwork at the courthouse or preparing for a hearing can be stressful, so we will try our best to explain the procedures and answer your questions. After completing the proper paperwork, your request will be processed. The case processing time varies and may take up to 30 days. During case processing, a judge is assigned and a hearing date and time are set. Notice of the hearing is prepared and sent to the appropriate sheriff's office for delivery. In general, your hearing will take place 60 to 90 days after you initially filed the paperwork. In civil matters like custody, visitation, and child support, you are not entitled to court-appointed counsel, but you may hire one. That's your choice. Many parents and legal guardians represent themselves during these proceedings. Everyone, regardless of whether they have an attorney or not, will have an opportunity to present their information to the judge. For information about legal aid opportunities in Virginia, visit valegalaid.org. If the court determines that your child's best interests must be safeguarded by an attorney, a guardian ad litem will be appointed. You may be responsible for paying the cost of representation of your child by a guardian ad litem. Free mediation services are offered to everyone in cases of custody, visitation, and child support. You will receive a referral to mediation either by mail or after your first court date. You can always call the mediation office to see if a referral is right for your case. The number is 804-706-2678. With the help of a certified mediator, mediation allows parents and legal guardians to decide the terms of the order. The discussions during mediation are kept confidential. The length of time mediation takes varies but may take up to 2 hours. The majority of those who attempt mediation resolve all their matters. When an agreement is reached, the mediator drafts an agreement, all parties sign, and it is sent to the judge for review. If the judge signs the agreement, your attendance in court will not be necessary and the agreement becomes an order of the court. The clerk's office will send a copy of the court's signed order through the mail. It is imperative that you keep a current address on file in the clerk's office. In the rare case that the judge does not sign the order, parents or legal guardians will be notified that they are required to appear in court. If an agreement is not reached, all parties will be required to attend an educational parenting seminar. The seminar should be completed within 45 days after the first court appearance, unless you've completed one within the previous year. The 4-hour seminar is offered both remotely and in person by qualified providers throughout the metropolitan region. No provider may charge more than $50 per parent for the course. A full list of qualified providers is available at the Chesterfield Juvenile and Domestic Relations District Courthouse and online at the Virginia Judicial System website. Spanish-speaking seminars are available. If your case was not resolved in mediation, you must attend your scheduled hearing. If you fail to appear, your case may be dismissed or you may be sanctioned. You may be able to attend by phone or video. Email your request to the clerk's office at least a week in advance. Explain why you need to attend remotely. A clerk will let you know if your request is granted. At your first hearing, the judge will hear from the parties and assess your situation. The judge may need to schedule another hearing to make sure you have enough time to fully explain. Whenever possible, the judge will do their best to see if a final order may be entered. If your case does require rescheduling, the judge will also go over what to expect at the next hearing by explaining the process and what the law says a judge must consider when deciding. At all stages of the process, you should be prepared to provide the judge information regarding your request. The Chesterfield Juvenile and Domestic Relations District Court follows a one-family, one-judge policy, meaning we strive to ensure you have the same judge at all your family's hearings. Sometimes, however, that is not possible. Please be assured that if a different judge is assigned to your case, they have fully reviewed the court's file. After your first hearing, if your matter could not be concluded, another longer hearing may be scheduled to allow enough time for parents or legal guardians to present information to the judge. At these hearings, witnesses testify and important documents may be presented by you or your attorney. More hearings may be necessary if more time is needed to present the information. Finally, a decision will be made by the presiding judge and his or her reasoning will be explained. Parents and legal guardians may appeal this decision, but they must file notice of their decision to appeal in the clerk's office within 10 days of the judge signing the order. During the appeal, a judge in another court, the Chesterfield Circuit Court, will hear the matter all over again. We want this process to be as straightforward as possible for you and your family. You should expect everyone at the courthouse to treat you with respect. We expect you to treat us and your family members with respect in return. The Chesterfield Juvenile and Domestic Relations District Court always seeks to act in accordance with the law and the best interests of children, just as you try to be the very best role model for your child.